Before the judge spoke, I already knew she had lost, and the strange part was she still believed this was her moment to win. The courtroom in Harris County, Texas felt colder than it should have, the kind of artificial cold that comes from air conditioning fighting a room full of tension, and I remember standing there with my hands folded, watching people take their seats as if this was just another routine property dispute instead of the unraveling of a marriage I once thought was unshakable. My name is Ethan Carter, and across from me sat Olivia Carter, my wife of 6 years, dressed like she was walking into a business presentation rather than the final chapter of our life together. She didn't look nervous, not even slightly, and that was the first warning sign that something in her mind had already decided the outcome. Her attorney leaned in close, whispering something I couldn't hear, but I didn't need to hear it to understand the tone. It was confidence sharpened into strategy. The judge, Raymond Hill, finally entered, and the room rose in unison, chairs scraping softly against the floor before silence settled back in like dust after movement. When we were seated again, Olivia adjusted her posture, subtly straightening her blazer, and that small gesture told me everything about how she saw this case, not as a question of truth, but as a transaction she expected to control. The ranch at the center of all this wasn't just land. It was 78 acres of Wyoming soil my grandfather had left me years before I even met her, a place where I learned what quiet really meant, where wind moved through open fields like it had nowhere else to be, and where every fence post carried memory instead of just wood and nails. I never thought I would have to explain its value to anyone, let alone defend its ownership in front of a judge. But life has a way of turning private history into public argument when trust breaks in the wrong direction. Olivia's voice broke the silence first, calm and rehearsed, stating her claim that the ranch had become marital property over time, that her involvement in our life gave her equal standing in its future, including the right to force a sale. She said it like she was reading from a document she had repeated too many times in her head, and I noticed a few people in the gallery shift slightly, reacting not to truth, but to confidence. I stayed quiet, not because I had nothing to say, but because I understood something she didn't yet realize, that in this room, volume meant nothing compared to documentation, and emotion meant nothing compared to origin. The judge listened without expression, pen resting lightly in his hand, eyes moving between us with the kind of patience that only comes from years of seeing people convinced they are right. When Olivia finished speaking, she leaned back slightly, as if she had just delivered the final word, and for a brief moment I almost felt sorry for her certainty, because certainty built on assumption always collapses the hardest. My attorney placed a folder in front of me, but didn't open it yet, waiting instead for the right moment, and I could feel the weight of what was inside without even seeing it. Years of paperwork, transfers, signatures, everything she never bothered to understand because she never thought she would need to. The judge finally spoke, asking us to confirm the nature of the asset in question, and I answered simply, clearly, stating that the ranch was inherited property, documented and recorded long before our marriage ever existed. Olivia didn't react at first, just a small tightening around her eyes, the first crack in a surface she had kept smooth all morning. Outside the courthouse windows, the Texas sun was bright, almost indifferent, as if it had no interest in what was about to happen inside this room. But inside, every detail suddenly felt sharper, every breath more deliberate, as if the air itself was waiting for the moment everything would change direction. The silence after my answer did not feel like relief. It felt like pressure building behind glass, and I could see Olivia's expression change in small increments as the meaning of my words began to settle into her understanding. She did not react immediately, which in some ways was worse than anger, because it meant she was recalculating instead of responding, and I had seen that look before, at kitchen tables, during late-night conversations, when she was deciding how a situation could be reframed in her favor. The judge turned a page in the file in front of him, the sound of paper moving in a quiet room suddenly louder than it should have been, and then he asked for clarification on the timeline of acquisition, his voice steady, neutral, the voice of someone who had heard every possible version of a broken marriage. My attorney leaned forward slightly and confirmed what I already knew, that the ranch had been transferred into my name years before the marriage, through a direct inheritance trust established by my grandfather, and every document supporting that chain was already submitted into evidence. Olivia finally laughed softly, not a real laugh, more like a reflex of disbelief, and she shook her head as if we were all missing something obvious. She said that ownership on paper did not reflect shared contribution, that years of marriage created rights that paperwork could not erase. And as she spoke, I noticed how carefully she avoided looking at me directly, as if eye contact might interrupt the version of reality she had built. The judge listened without interruption, and I could feel the weight of the room shifting, not dramatically, but in subtle ways, like people adjusting their understanding without admitting it out loud. I thought back to the first year of our marriage, when things were simple enough that we could drive out to the ranch on weekends, bringing coffee in insulated cups, and sitting on the porch while the wind moved across the fields. And Olivia used to say it felt like another world out there, peaceful, untouched, something she admired but never truly understood. That memory felt distant now, almost like it belonged to someone else, because somewhere along the way admiration had turned into calculation, and what once was curiosity had become assessment. The judge asked Olivia's attorney to present their legal basis for the claim, and for the first time I saw hesitation, a slight pause before he responded, referencing marital property statutes, contributions during marriage, and perceived commingling of assets. But even as he spoke, it sounded less certain than before, as if the foundation beneath their argument had started to shift. Olivia leaned forward slightly, whispering something urgent to him, and I caught fragments of frustration in her expression, the kind that appears when a plan meets resistance it did not anticipate. My attorney placed one additional document on the table, but did not submit it yet, waiting, and I understood why, because timing in a courtroom is not just procedural, it is psychological, and the right moment can determine how a truth is received before it is even fully revealed. The judge then asked a simple question about whether any financial investment from marital funds had been used to maintain or improve the ranch, and the room seemed to tighten around that question as if everyone recognized it as a turning point. Olivia answered quickly that there had been indirect contributions, general financial support, shared household income that ultimately made the property sustainable, but her explanation began to drift as she spoke, becoming less precise, more emotional. I stayed still, watching her, noticing how confidence can sometimes hold until it is required to define itself in specifics, and then it begins to weaken. The judge made a note, then looked back at the file again, and for the first time there was a longer pause, the kind that signals examination rather than routine processing. I could feel my heartbeat steady rather than accelerate, which surprised me, because I had expected to feel more conflict inside myself. But instead there was only clarity, a strange calm that comes when something you have known privately is finally being seen publicly. Olivia glanced toward me briefly, and in that moment I saw something beneath her composure, not fear exactly, but uncertainty creeping in at the edges, as if she was beginning to realize that the structure she built her argument on might not be as solid as she believed. The judge finally closed the folder slightly, looked up, and asked for confirmation of the original trust documents again, specifically the clause regarding inheritance exclusion, and the air in the room seemed to shift once more, as if the real question had finally been asked, not about emotion or marriage, but about origin and legal separation. My attorney nodded and prepared to respond, and I realized that everything up to this point had only been the surface, the beginning of something that was now about to move deeper, into the part where assumptions would no longer be enough to hold a case together. The question from the judge about the original trust documents landed in the room with a different weight than anything that had been said before, because it was no longer about interpretation or emotion. It was about structure, and structure does not bend easily to argument. My attorney finally opened the folder in front of him, sliding out the certified copies with the calm precision of someone who had done this many times before, and as he placed them on the table, I could hear the faint shuffle of attention shifting across the courtroom. He began to explain, in clear and measured terms, that the ranch had been placed into an irrevocable inheritance trust decades before my marriage, that the language explicitly excluded marital classification, and that no subsequent action had ever altered that designation. The words were simple, but their effect was not, because simplicity in a courtroom often signals finality rather than reassurance. Olivia's attorney leaned forward quickly, attempting to interrupt with a counter-interpretation, suggesting that long-term marital residence and shared life integration could still create equitable claims. But the judge raised a hand slightly, not in anger, but in control, signaling that he wanted to hear the foundation before any argument about its edges. Olivia shifted in her seat for the first time since the hearing began, a subtle movement that betrayed something beneath her composure, not panic, but the realization that the direction of the room was no longer aligning with her expectation. I remember noticing how she avoided looking at the documents directly, as if not seeing them might preserve her position, but avoidance has never changed recorded history. The judge asked for the specific clause regarding exclusion from marital assets to be read aloud, and my attorney complied, his voice steady as he read the language that had been written long before either of us had ever imagined this moment. It stated clearly that the property was to remain separate under all conditions, immune to division, transfer, or claim arising from marriage, and each word felt heavier than the last as it settled into the silence of the room. I glanced briefly at Olivia and saw her expression tighten, not dramatically, but enough to recognize that something internal had begun to shift, like a calculation reaching an unexpected result. She leaned toward her attorney again, whispering more urgently now, and I could see him shake his head slightly, a subtle acknowledgement that the path they had built their case on was narrowing quickly. The judge then asked a follow-up question, this time directed at whether there had ever been any legal amendment, verbal agreement, or written modification that could override the trust conditions, and that question changed the atmosphere again, because it moved from interpretation into verification. Olivia answered immediately that there had been discussions, shared understanding within the marriage, and the belief that mutual contribution naturally altered ownership over time. But even as she spoke, it was clear she was stepping further into concepts rather than facts. My attorney waited until she finished, then calmly submitted the final set of documents, including recorded filings and state registry confirmations, each one reinforcing the same conclusion from a different angle, and I watched the judge review them without expression, his eyes moving in a rhythm that revealed nothing of his thoughts. The room felt narrower now, not physically, but in attention, as if every person present understood that the space for interpretation was closing. I thought back briefly to how often Olivia had spoken about fairness in our marriage, how she would use that word in conversations about money, decisions, and future planning. But fairness and legality are not the same language, and only one of them matters in this setting. The judge finally spoke again, this time more deliberately, summarizing what had been established so far, and confirming that unless contradictory evidence existed, the ranch remained separate property under irrevocable trust protection. Olivia's attorney attempted one final argument, suggesting that intent and marital conduct should still weigh heavily in equitable consideration. But even as he spoke, his tone lacked the certainty it had carried earlier. I could feel the shift complete itself in that moment, not with drama, but with quiet resolution, like a door that had been slowly closing, finally reaching its frame. Olivia sat very still now, her earlier confidence replaced by something more contained, not collapse, but recognition that the structure around her claim had stopped responding. The judge closed the folder gently, looked across the room, and asked if either side had additional evidence that would change the legal classification of the property, and the silence that followed was not hesitation, it was absence. For the first time since the hearing began, I realized this was no longer a question of who wanted what, but of what the law had already decided long before any of us walked into the room, and that realization settled in without triumph, only clarity. The moment the judge asked whether any additional evidence existed that could alter the legal classification of the property, I felt something shift in the room that had nothing to do with sound and everything to do with finality, because questions like that are never casual in a courtroom. They are the last open door before a decision becomes irreversible. Olivia remained still, but it was no longer the stillness of confidence. It was the stillness of someone waiting for a foundation to either hold or disappear beneath them. My attorney did not speak immediately, and that silence was intentional, because he understood timing in a way that made silence part of the argument itself. He finally reached into the final section of the file and placed a single additional document on the table, not dramatically, but with enough precision that everyone noticed. It was a certified confirmation of the original inheritance filing, cross-verified through county registry records. including time-stamped documentation that predated our marriage by years, and as it was introduced, I saw Olivia's expression tighten in a way she could no longer control. She leaned toward her attorney quickly, whispering something sharper now, but this time he did not respond with reassurance, only a slight shake of his head, because some arguments do not fail loudly, they simply stop being viable. The judge reviewed the new document without interruption, scanning line by line, and I noticed how his pen stopped moving entirely, which in my experience meant he was no longer taking notes for clarification, but confirming conclusion. Outside the courthouse windows, the light had shifted slightly, the afternoon sun now angled lower, casting longer shadows across the floor, and it felt strangely symbolic, as if time itself had started to move toward resolution. Olivia finally spoke again, her voice lower now, attempting to reframe the argument around fairness, contribution, and shared life investment. But the words no longer carried the structure they once had. They sounded like they were searching for legal footing that had already been removed. I remembered how easily those same words had once worked in private conversations, how we built this together had sounded reasonable when there was no formal distinction being examined. But in this room, language without legal support becomes only sentiment, and sentiment does not divide property. The judge finally leaned back slightly, exhaling in a way that suggested not frustration, but clarity, and then he began to speak in a measured tone that drew the attention of everyone present back into absolute focus. He summarized the chain of ownership again, slowly, deliberately, confirming each point as if sealing them one by one into record, and with each sentence Olivia's posture became less reactive and more contained, as though she was realizing there would be no unexpected turn left to rely on. My attorney remained still beside me, hands folded, not looking at anyone, because at this stage of a hearing, confidence is no longer expressed through words, but through the absence of need to speak. The judge then addressed Olivia's claim directly, stating that equitable contribution does not override clearly defined inheritance exclusion when supported by unbroken legal documentation, and the weight of that statement settled across the room without resistance. Olivia looked down for the first time, not in defeat, but in the kind of pause people take when they are forced to reconcile belief with recorded fact. I did not feel satisfaction in that moment, only distance, as if the version of this situation I had been carrying for months had finally been set down and was no longer mine to hold. The judge closed the file slowly, and that small action carried more finality than any sentence that had been spoken, because it marked the end of uncertainty rather than the start of consequence. He then stated that the court would proceed toward ruling based on established documentation, and there was no additional argument requested from either side. Olivia remained seated, her hands still now, no longer searching for explanation or correction, while I sat across from her, understanding that nothing about this moment had been sudden. It had simply taken time for the truth to move through every layer of assumption until it reached the surface, where it could no longer be reshaped. The room felt quieter than before, not because sound had changed, but because uncertainty had finally been removed from it. The judge's decision did not arrive like a sudden announcement, but rather like a conclusion that had been forming quietly through every document, every clause, and every pause in the courtroom. And when he finally began to speak, the entire room seemed to lean forward without realizing it. His voice was steady, controlled, and unmistakably final in its direction, confirming that the property in question remained legally classified as separate inheritance under irrevocable trust protection, not subject to division under marital assets. Each word he spoke reinforced what had already been established, but hearing it aloud transformed the information from legal interpretation into permanent record, and I could feel the atmosphere change in response to that shift. Olivia did not interrupt, and that silence told me more than any argument she had made earlier, because it was no longer strategic silence, it was acceptance forming in real time. Her attorney sat back slightly, no longer leaning forward, no longer searching for angles, because there were none left that could be argued within the boundaries of law. The judge continued, addressing the record directly, stating that the court found no valid basis to classify the ranch as marital property, and therefore no legal grounds existed for forced sale or division. I remember the sound of the pen in his hand stopping completely, as if even the act of recording had reached its endpoint. Outside the courthouse window, the light had shifted further, the late afternoon sun now casting long, angled shadows across the floor, and I noticed how something so ordinary suddenly felt aligned with what was happening inside. Olivia finally lowered her gaze, not dramatically, not in collapse, but in a quiet stillness that suggested the structure she had relied on had dissolved without needing conflict to break it. I did not feel triumph in that moment, only distance, as if I was watching the end of a process that had already finished emotionally long before it ended legally. The judge asked once more if there were any procedural objections, and both attorneys remained silent, because silence was now the only accurate response available. He then stated that judgment would be entered in accordance with the documented trust agreement, and that the matter of ownership was legally settled. Those words did not carry emotion, but they carried weight, because in a courtroom, emotion is irrelevant once classification has been confirmed. I looked across the table at Olivia and saw something unfamiliar in her expression, not anger, not disbelief, but the quiet recalibration that happens when a plan no longer has a future to attach itself to. The room itself seemed to exhale slightly, not because anything had been released, but because uncertainty had finally been removed from the space. My attorney closed the folder in front of him, not abruptly, but with the calm precision of someone who knew the work was complete, and I realized that every page inside it had been leading to this exact moment of closure. The judge gathered his papers, preparing to move on to formal entry of judgment, and the sound of paper aligning felt unusually final, like the last piece of a structure being placed into position. I sat still, aware that nothing more needed to be said, because everything that mattered had already been confirmed through documentation rather than argument. Olivia remained seated as well, no longer engaged in strategy, no longer searching for leverage, simply present in the reality that the court had defined without ambiguity. In that quiet, I understood something simple but permanent, that some outcomes are not won through confrontation, but revealed through clarity, and once that clarity arrives, there is nothing left to persuade, only something left to accept. The moment the judge moved from verbal confirmation into formal entry of judgment, the energy in the courtroom shifted again, not because anything new was being decided, but because what had already been decided was now becoming permanent in record. He spoke with the calm precision of someone finalizing a conclusion that required no further interpretation, stating that the court would recognize the ranch as exclusively separate property under irrevocable inheritance trust protection, and that no marital claim could be applied under existing state law. The words were simple, but they carried the weight of closure, the kind that does not invite discussion or appeal in that moment. I noticed Olivia's posture change subtly as the judge spoke, not collapsing, not reacting outwardly, but settling into a quiet stillness that suggested she was no longer participating in the outcome, only witnessing it. Her attorney gathered his notes slowly, no longer attempting to adjust strategy, because strategy had already reached its limit inside the boundaries of what the law would allow. When the judge finished speaking, there was a brief pause that felt longer than it should have, the kind of pause that exists after something irreversible has been confirmed but before people decide how to carry it forward. I remember looking down at the table in front of me, not out of emotion, but out of a strange sense of distance, as if I was observing the conclusion of a situation that had once felt overwhelming but now felt structurally complete. The judge then instructed the clerk to prepare the final order for entry, and those words carried a different kind of finality, because they marked the transition from spoken ruling to documented reality. Olivia finally exhaled slowly, the first visible sign of release from her that day. But it was not relief, it was recognition, the kind that comes when a belief system meets a boundary it cannot cross. She did not look at me, and I did not look at her, because there was nothing left in that direction that required acknowledgement. My attorney closed the folder in front of him with a controlled motion, signaling that his role in this hearing was complete, and I realized how much of this outcome had been determined long before we ever entered this room, through documentation that existed independently of emotion or narrative. The judge gathered his papers, and the sound of pages aligning was the only movement in the room for several seconds, as if even time was adjusting to the completion of its own segment. I could feel the attention in the room beginning to loosen, not because the situation had become less important, but because it had become resolved within the system that governed it. Olivia remained seated, her hands resting still in front of her, and I noticed that the tension she had carried earlier had transformed into something quieter, something that no longer searched for resolution because resolution had already been defined externally. The clerk began preparing the formal entry paperwork, and I understood that what had just happened was no longer part of argument or perspective, it was now part of record. The judge gave a final procedural instruction, confirming that the case would proceed only for administrative closure, and there was no further need for testimony or objection. In that moment, I realized that the most important part of the hearing was not the conflict itself, but the point at which conflict stops being relevant. Because classification has already been established, I sat there quietly, not feeling victory, not feeling loss, but something closer to completion, as if a long process that had occupied too much space in my life had finally been reduced to something finite, contained, and no longer capable of changing shape. The clerk's voice broke the remaining stillness in the courtroom as she began preparing the formal entry of judgment, her tone neutral and procedural, but it carried a kind of final authority that only exists when a decision stops being spoken and starts being recorded into law. I watched as documents were gathered, stamped, and aligned, each movement small but deliberate, as if the room itself was transitioning from debate into history. The judge remained seated for a moment longer, reviewing the final notes in front of him. Then he signed the order with a single continuous motion that felt unremarkable in appearance, but absolute in consequence. Olivia sat across from me without moving, her hands resting together on the table, no longer performing confidence, no longer searching for argument, simply present in the reality that had already been defined. There was no outburst, no dramatic reaction, only a quiet stillness that felt heavier than anything that had been said earlier. My attorney closed his folder completely and leaned back slightly, a subtle sign that everything required had been completed, and I realized how long this moment had been building towards something so structurally simple. The judge gave a brief instruction to the clerk regarding distribution of the order, then stood, signaling the official end of the hearing, and just like that, the formal part of the case was over. People in the gallery began to move slowly, chairs shifting, papers being collected, the natural noise of an ending that does not announce itself but arrives through small physical actions. I remained seated for a few seconds longer, not because I needed time to process, but because I was observing how quickly something that had carried so much emotional weight could be reduced to procedural completion. Olivia finally stood as well, her movements measured, controlled, but different now, as if she was adjusting to a version of reality that no longer responded to expectation. For a brief moment, she looked toward the exit instead of toward me, and I understood that the direction of her attention had already changed before either of us spoke again. My attorney placed a hand lightly on my shoulder and nodded once, not in celebration, but in acknowledgement that the legal objective had been fully achieved, and I responded with a simple nod of my own, because nothing more was required. As I stood, I noticed how quiet the room felt now that the judge had left, not empty, but settled, like a space that had completed its purpose and no longer needed to hold tension. Olivia gathered her belongings slowly, pausing once as if reconsidering whether there was anything left to say, but she did not speak, and neither did I, because anything spoken at that point would have belonged to a different version of the situation that no longer existed. We moved toward the exit at different times, not in conflict, not in alignment, just in separation that had already been defined long before this moment. The hallway outside the courtroom was brighter than the room we had just left, sunlight reflecting off pale walls and polished floors, and I remember noticing how ordinary everything felt compared to what had just been decided inside. A few people passed by speaking quietly, unaware of the significance attached to the steps I was taking, and that contrast made the experience feel even more contained, almost private despite its legal formality. Olivia walked a few steps ahead of me before slowing, then continued without turning back, and I understood that there was nothing unresolved in her movement, only conclusion. I paused near the end of the hallway for a moment, not reflecting on what was lost or gained, but recognizing that a chapter one had carried for a long time had reached its natural endpoint without needing escalation or confrontation. The ranch, The inheritance, the years of assumption and doubt, all of it had been reduced to a single confirmed reality inside a legal system that did not interpret emotion, only documentation. As I stepped toward the exit doors, I felt a quiet sense of distance from everything that had brought me here, not because it no longer mattered, but because it had been fully accounted for, and there was nothing left unexamined or undecided. The doors opened, and the light outside was steady and unchanged, as if the world had continued at its normal pace regardless of what had just been finalized inside. The moment I stepped outside the courthouse doors, the difference in atmosphere was immediate, as if the entire weight of the hearing had been contained within those walls and could not follow me into the open air. The sunlight in Harris County felt warmer than I remembered, not because the temperature had changed, but because the absence of procedural tension made everything around me feel lighter by comparison. I paused for a moment near the top of the steps, letting the sound of the city replace the silence of the courtroom, cars passing on the street, distant voices, the normal rhythm of a weekday afternoon that continued regardless of what had just been decided inside. Behind me, Olivia exited a few seconds later, accompanied by her attorney, her pace steady but no longer directed toward confrontation or argument. There was no acknowledgement between us, no final exchange, only parallel movement in different directions, as if the case had removed the need for any remaining connection between our paths. I watched briefly as she reached the sidewalk, then turned toward a waiting vehicle, her posture composed but no longer projecting the certainty she had carried earlier that day. My attorney stepped beside me and adjusted his briefcase, then spoke in a calm voice that matched the tone of everything that had just concluded, stating that all formal obligations from his side were complete and that I would receive certified copies of the judgment within a few business days. I nodded, not because there was anything left to agree upon, but because acknowledgement felt like the only appropriate response to something already finalized. As he left toward his own vehicle, I remained standing for a few more seconds, not thinking about strategy or outcome, but simply observing how quickly a process that had once felt overwhelming had now been reduced to paperwork and closure. The ranch, which had been the center of argument for weeks inside my mind and for hours inside that courtroom, now existed in a different state entirely, no longer subject to interpretation or challenge. It was no longer a question, no longer a claim, but a defined legal reality that existed independently of emotion. I began walking toward my truck parked across the street, noticing how ordinary everything looked again: pedestrians crossing at the intersection, a traffic light cycling through its colors, a delivery truck idling near the corner, all of it continuing without awareness of the internal shift that had just taken place in my life. When I reached my vehicle, I paused before opening the door, resting my hand briefly on the frame, not in hesitation, but in recognition that I was transitioning out of a chapter that had consumed far more mental space than physical time. Inside the cab, the air was still warm from the Texas sun, and for a moment I sat without starting the engine, letting the quiet settle in a different way than it had in the courtroom, less structured, more natural. I thought briefly about Olivia, not with anger or relief, but with a sense of distance that comes when a shared reality stops being shared and becomes separate histories. Whatever she had expected from this process, it no longer aligned with what had been recorded into law, and that gap between expectation and documentation was now final. I started the engine and pulled away from the curb slowly, merging into traffic as the courthouse receded in my rearview mirror, no longer the center of anything, just another building in a city that continued moving forward. As I drove, I realized that nothing external needed to change for my situation to already be different, because the change had not been in the environment, but in the removal of uncertainty that had once defined it. The ranch remained untouched, legally and structurally secure, and with that clarity came a quiet understanding that some outcomes are not about winning or losing, but about the restoration of boundaries that were always present but temporarily questioned. The road ahead felt uninterrupted, not because everything was resolved emotionally, but because everything had been resolved structurally, and for the first time in a long while, there was nothing left to argue against, only a path forward defined by what had already been confirmed. The drive away from the courthouse did not feel like escape. It felt like the slow return of something I had not realized I had been missing, a kind of mental quiet that only appears after prolonged uncertainty finally loses its authority over your thoughts. The traffic on the highway outside Harris County moved at its usual pace, trucks passing in steady intervals, sunlight reflecting off windshields in brief flashes that came and went without meaning, yet for the first time in a long while, none of it felt intrusive. I kept both hands on the steering wheel, not out of tension, but out of habit, and I noticed how different habit feels when it is no longer attached to stress. My phone buzzed once in the passenger seat, a notification I did not immediately check, because for the first time in months there was nothing urgent behind it that could redefine my day. I thought about Olivia briefly, not in fragments of conflict, but as a full timeline that now belonged to the past, and what stood out was not anger or satisfaction, but the absence of ongoing interpretation. Everything that had once required explanation had already been reduced to documentation, and documentation does not evolve once it is finalized. As I continued driving, the city gradually gave way to wider stretches of road, the kind that open into fields and long horizons, and I realized I was unconsciously heading towards something I had not visited in a long time, the ranch itself. The road there was familiar, almost muscle memory, each turn bringing back quieter versions of myself that existed before legal language ever became part of my daily vocabulary. When I finally crossed into the property boundary, there was no dramatic shift, no symbolic moment of transformation, only the simple visual confirmation of land that had remained unchanged regardless of everything that had been argued about it. The gate was exactly as I remembered it, slightly weathered but solid, and when I stepped out of the truck to open it, the air felt different in a way that was difficult to define, not better or worse, just unpressured. Driving up the gravel path toward the main structure, I noticed how the sound of tires on stone replaced the noise of traffic almost completely, and with that change came a level of mental silence that felt unfamiliar after everything that had taken place in the courtroom. I parked near the house and sat for a moment without moving, looking out over the open fields that stretched beyond the fence lines, and I understood something simple that had been obscured during the legal process, that ownership is not always about possession, but about continuity. These acres had existed long before any dispute, and they would continue long after, unaffected by interpretation or disagreement. I stepped out of the truck and walked slowly toward the porch, noticing how the boards creaked in the same way they always had, unchanged by time or circumstance. The house itself felt less like a symbol now and more like a fixed point, something that remained stable regardless of the instability that had surrounded it. I stood there for a long moment, hands resting on the railing, looking out across the horizon where the land met the sky without interruption, and I realized that the entire legal battle had not altered the ranch in any physical sense, only my awareness of how firmly it had always been defined. There was no sense of victory in the way people often imagine it, no internal celebration or emotional release, only the recognition that something contested had finally returned to its natural state of clarity. As the sun began to lower slightly in the sky, casting longer shadows across the fields, I felt the weight of the past week settle into perspective rather than presence, no longer pressing forward into the present moment. I understood then that the courtroom had not given me the ranch. It had simply confirmed what had already been true, and that confirmation was the only thing that had changed. Standing there in the quiet of open land, I realized that the most significant shift was not external at all, but internal, the removal of doubt that had once made everything feel uncertain. And as the wind moved lightly across the fields, steady and unchanged, I finally felt the difference between something being taken, something being lost, and something simply being recognized as it always was.